This is Professor Bell, and this video is being recorded for two reasons. First, I want to offer some tips to ensure your success in classes that I teach for law students. And secondly, I want to offer some insights on what it takes to be successful on any exam that I would give or on a bar exam, whether it be Louisiana bar or any other bar exam that requires essay responses. So we'll be discussing both topics separately. The first one, of course, is going to be tips for success in class. So I'm going to start by sharing the screen. And at this point, everybody should be looking at a document that is captioned Secrets to Success. And the very first thing that I'm going to ask of you this semester is that you begin to get acquainted with two terms. These terms are essential for not just success in classes that I'm going to teach, but success in the field of law as well as in law school. The first term is called metacognition, and that is a term that requires us to get to a place where we learn how we learn. So if you look on the screen, you're going to see the scholars giving a scholarly definition, but I just want you to walk away from this conversation recognizing that metacognition is a word that you need to know. And we need to begin, as we start this semester, comprehending that learning is an art, and learning is an art form that is going to be expressed differently and accomplished differently by each student. The task of this video is to get you to begin to do the work of thinking about how it is that you learn, because you cannot achieve success without understanding how to be a successful learner. Some students are going to learn simply by coming to class and listening to lectures. Other students are going to learn by reading before and reading again after lecture. Some students are going to learn by actually having to do charts and diagrams. Some students are going to learn by outlining. Some students are going to learn by group sessions where they may talk with other people. Some students are going to learn by needing to troubleshoot terms and conversations that we have in class, out of class. And so what I'm going to do as a professor is try to accommodate all of these various learning styles. So I'm going to do my part to accommodate. The problem is, if you don't know how you learn, there's nothing that I can do to help you be successful in this course. So we're going to start the course by talking about the first task that I'm asking of every student is to go begin to do the work of figuring out, how do I learn? After you begin to understand how you learn, there is a journey that you'll be on throughout the semester to be able to learn certain aspects of a subject matter. And also simultaneously, while you're learning the Black letter law and the application of the law, you're going to be learning exactly how do I think at this moment, and learning how to improve your critical thinking skills, which introduces us now to the second term that I want us to know, which is called Bloom's taxonomy. That term, again, has this scholarly definition on the screen, but essentially, Bloom's requires us to think about the fact that our thinking gets more advanced and more sophisticated over time. So when we start as preschool students, we're learning, if you look at this illustration on the screen, at this purple box, the goal when you're in preschool is simply to learn how to memorize things, to remember things, to associate a visual with a word. So for example, when you're in preschool, the teacher's gonna grab a round thing that's red and say, hey, this is an apple. And the goal is for you to always remember, to memorize that when you see that red round fruit, to say the word apple. So the expectation for an elementary school student, it's not going to be the same for a student that is a toddler in pre-K. The point here is that the expectation for a college student is not going to be the same as a law student. And so whatever you were doing to have success as a pre-K student, as an elementary school student, as a high school student, as a college student, even maybe as a graduate student, it is not going to lead to success in law school. Why? Because law school requires a very, very sophisticated level of thinking and analyzing. I'm stressing this because a large part of your 1L year, when you take legal writing, if you notice carefully, that course is not called legal writing. It's called legal writing and analysis for a reason, because your 1L year is about not just learning how to write like a lawyer, but how to analyze and think critically like a lawyer. My experience, unfortunately, is that I am teaching 2 and 3L students who didn't get this foundation. And so I start all of my courses by saying this because I don't want to assume that you were taught this as a 1L. So what you must comprehend is you don't just read or write to be successful as a lawyer or a law school student. You must read and write after you've developed the ability to analyze critically. And so what Bloom's does is force everyone to self-assess and figure out, in these 6 boxes or 6 spaces on this triangle, where are you at the moment? That is question 1. But that is not the important question. The important question is, what does it take for me to get to the top? And so often when we speak in class, or if I'm going to be talking to you through things you write, you might get comment or feedback from me saying you need to get to the top of Bloom's. Or I may say to you, you need to get off the bottom of Bloom's. Or I may say that being in the middle of Bloom's is not a sign of success for a future lawyer. And what I mean by that is that you should understand now that Bloom's is really based on 6 levels of thinking. The very basic bottom line level is just to remember, and that is something that was acceptable when you were between 3 and 6. The second level is that you are supposed to now be operating in a much more sophisticated space. So I don't expect for you to do in law school what you did when you were 3, 4, 5, and 6. That is not acceptable. What I expect in law school is not even for you to show me that you understand, because that understanding level is just a demonstration of what you should have been able to do in elementary school. And what understanding essentially does is tell us that you can sort of make comparisons between the things that you memorize, and that you could recognize some basic concepts. That's all you do when you understand, is demonstrate some awareness of concepts. It's very basic skills here. So when you're down at this bottom purple box, the blue box, you're performing at an elementary school stage. And then we get to this third box, which is the applying box. And we're now progressing into a place of maybe middle school. So if you look at 3, what is it asking us to do? We're doing some problem solving here. Not complicated problem solving, but some very basic problem solving. We're going to move up from the problem solving box, which is that apply box, to the 4th level, which is now where we're analyzing. So we're going now to like that middle high school place. Here where we're identifying steps and figuring out how pieces and parts might work together when we get to this 4th space. So take a look at how they describe it on this chart. We're breaking information into smaller parts. So we're thinking now in a more integrated way. We're differentiating. We're comparing things now. So we can see ourselves doing things in high school clearly that we could not do in the preschool boxes and then the elementary school boxes. So our level of thinking is maturing. It's improving, it's expanding. And then, of course, we get now to where we're about high school, college, this evaluating box, which tells us now that we're using informations here to make judgments. We're arguing points. We're weighing positions here. We're defending maybe the positions that we're taking. We're critically judging the positions that others are espousing when we get to that fifth space. Um, Take a look at the more detailed explanation. It is interpreting information. It is illustrating the thought processes that we have. And then, of course, the goal here is to get to the very, very top, which is this create box. Create now is when I am functioning totally the way a legal mind should function. At this place, I can actually author my own solutions. I can investigate problems and come up with a potential argument for how it is that we may solve this problem. I can generate something very new and something very original based on my reasoning, me fusing together perhaps other explanations that were offered for something similar but does not identically match. So I'm going to fuse 2 or 3 scenarios together to come up with one. That is when we are achieving what a law student should achieve. Now, for about 10 years, I taught legal writing. And my initial lecture was just like the one I'm having now, which is where I would say to a first-year law student coming into law school that we want to look at a problem and we want to analyze if that thing works as it is or if that thing needs to be upgraded or improved. And if we think it needs to be improved, we want to figure out how do we improve it. Now, I may be talking in abstractions, so I want to give a couple of examples so that this conversation actually does make sense to you. So one of the first things I'm going to ask you to think about is when you have a legal issue that you need to solve. For example, the legal issue that you want to solve. I'm on a task force at this moment, and the task force that I'm on is intending to solve the problem of whether Louisiana needs to have a change in its law of principles. So the way Louisiana law works right now is that if 2 people are in a vehicle and those 2 people say, hey, we are going to snatch a lady's purse. That's all I'm willing to do. We're just going to snatch the purse and then we're going to run with the purse or we're going to drive away with the purse. That's the agreement these 2 people make. And one person gets out of the car with the agreement that we're here just to snatch a purse. And the driver of the car is supposed to be ready to drive off once that person gets the purse. Well, in this instance, the person goes to get the purse, and unexpectedly, this person that they thought was a little old lady is actually a black belt. And she fights back and she's starting to win, and she gets a gun out of her purse and she's now ready to shoot. And so this person now has to shoot in defense of their life. And so they kill this person. And none of this was supposed to be the plan. The driver's in the car saying, no, no, don't kill her, don't shoot her, let's just go. I don't want to even take a purse at this point. But the other person continues to do all of these things that nobody agreed to have happen. Well, under Louisiana's law of principles, those 2 people are going to be charged just alike. The driver who's in the car saying, I don't want any part of this, but of course that driver never went to report that this thing happened after the fact. And then the actual murderer, the actor, the person who made the sole decision to actually take a life, they're going to get the same charges. And so now I'm on this task force. This is a true story. And the question is that justice? Is that the way we want to administer justice in the state? Do we want to charge both of those people in the very same fashion, give them the same sentence? And in this case, the way that would play out is that you're dealing now with people who are going to end up likely with life sentences. Well, that calls not for remembering anything because this is a new problem. This is a question that we need an answer to. So we can't operate in this purple box. There's nothing to understand because there's no solution. We're to find the solution. We can't apply any precedent because this is the law that we have. There is no comparison law. Our job is to figure out whether we want it or not. There's nothing to analyze at this point except maybe to compare what other states are doing, but we're not bound by that. In fact, we're the only civilian jurisdiction, so whatever they do wouldn't even matter, right? Because we're different. So now we are evaluating. So this is the work of lawyers, this orange box, this red box, evaluating the current state of affairs. Look how this is described, where we're making appraisals about our law. We're making some critiques about this law, but most importantly, the task is now to create something, to decide if creation is the solution. How do we do that? Well, we have to investigate the law we have. Investigate the law means that we have to make some decisions about whether this is the policy that we want to have as a state. Investigate means that we have to maybe pull some of the cases of people convicted under this and figure out if these people should be equally accountable in these situations, or do we have cases maybe where people truly are being overcharged and this is not really justifiable. And so what I am suggesting to you is, in order to get out and practice law successfully, in order to be successful as a law student, if you cannot create on your own, if you need someone to help you create, you will not see success in this course. And so the goal from the first day to the last day is to, one, decide where am I when I start. And I'm going to tell you, it's rare that somebody's in the red box. It's also rare that somebody's in the orange box. What is more typical is that students are usually around that green and that yellow box. And by the end of a semester or the end of several semesters, they can see themselves moving up to the top. Again, because I love to accommodate different learning styles, I'm going to show you the same thing said different, because I want you to see. I love this visual here because it actually shows you literally moving. Because what do you do on steps? You don't walk up one step and remain there. That defies the object of steps. Steps is to help you progress, right? To get from the bottom to the top, to elevate yourself. That's the goal of steps. And so I love this illustration because what it's showing us is that when we take the first step, remember that's the preschool kid, we got to go up to the next step, which is the elementary school steps. And then we have to go up to the middle school, and then we go up to the high school and the college, and then this professional space that we're operating in. And so what I am challenging you to understand is that if you are functioning at these bottom steps, which is what you should have been doing many years back, you are probably ending up in this course with D's and F's. In order to be able to achieve a C, a B, or an A, you're going to have to train yourself how to think in a way more sophisticated way. And that is what my job is. And so much of what we will do this semester is not me helping you find the holding of a case or find the facts of a case or find the issue of a case, because I'm going to assume that you are proficient at that. I'm going to assume that as a 1L that was taught to you, maybe in pre-law even. And so you don't need that from me. You can do that without my help most of the time. What you need most from me is, once you remember what you read and you understand what you read, my job comes in helping you to apply the reading, helping you analyze that reading, helping you to evaluate that reading, and helping you to create something new with that reading, because that's what the final exam is. It's your create space. It's your second-degree murder task force, where you're now going to be given some type of scenario and asked to create a legal solution. And so why I say this is because there are students who enter my class and think that if I read a case the night before and come ready to tell her that I remember or that I understand, or apply, I've done really well. And that leads to absolutely nothing. In fact, I would deem that failure. Success looks like I've read that. I personally remember what I read. I understand it. I'm able to apply it. That's not what I show up in class to do, however. I'm in class to be able to engage in the work of analyzing. I'm in class to evaluate. I'm in class to create. And I want you to look at how that is described. So evaluate means that I'm distinguishing, I'm comparing what I read to this new scenario that I walk into when I report to class. Evaluate means that I am being asked now to justify the position that I'm giving in class. I'm being asked to maybe argue an adverse position. Create means that when I get to class, I am producing something very new, unknown, that was not in the book, that I am now being said, build from what you read. So what I am saying in short is that you would never come to class expecting of me those predictable questions like, what's the holding? Or what's the facts? Because oftentimes I'm going to give you that. I mean, there's no real challenge to that. Remember, that's all about remembering and understanding. What you should expect when you come is this journey from applying to analyzing to evaluating and creating. Okay. And so I'm saying that to you because this type of preparation requires something very different than simply reading. This type of preparation requires multiple steps. So one, I read. Two, after I read, I go through these green, blue, purple boxes in my head with my study group, on the phone with my friends. I deliberate if this new scenario should happen, but I just learned this old law, or at least the current law. How does it lend itself to this new scenario? So that's step two, reading and then doing the mental work. And then step three is going to involve you actually coming to class, participating in discussions, and sometimes participating is nonverbal. Sometimes participating is sitting and critically listening, actively listening, understanding what other people are saying so that when you hear it, it makes sense to you. If it doesn't make sense to you, raising your hand and saying, can you help me? I don't comprehend what I just heard. And so being in class doesn't always require you to speak. Being in class doesn't always require silence. And so that is the third step, is simply being present. And then, of course, the final step is once you leave class, I expect every student to constantly, every single time you leave class, to go and update an outline, not by typing in the name of the case, the facts of the case, the issue, the holding. I'm not expecting that. In fact, that's a waste of time. What I am expecting you to do is say, what about that case did we learn relative to the green box? And what about that case did we learn relative to the blue box? And what about that case did we learn relative to this purple box? And then those notes, those comments go into the outline. There's some other things that you're going to put in your outline. For example, I will often say this is a term of art. This term of art is really, really important on an exam. This term of art has special meaning. So if you hear me say things like that, there should be notes in your outline that there's a term of art that comes from this case that I need to now be able to explain that term of art on an exam and be able to apply that term of art on an exam. And then, of course, there are times where case names are relevant. Those times are few, but they do happen. And at that time, you be told that this is a landmark case. So when you're on an exam, I would expect you to be able to drop the name of this case. And again, I know that is rare, but there are times where that is going to be expected. I also oftentimes will give you very, very clear hints that this is an area that is going to be tested. So you would be making notes like that in your outline. And it is my routine to tell you what is predictable when it comes to bar prep. So there are subject matters in criminal procedure, and constitutional law that are always, always, always tested on a bar exam. For example, the concepts of due process, the idea of privileges and immunity, First Amendment issues, Fourth Amendment issues. Those things are always going to come up on a final exam. They're always going to come up on a bar. And so when you're in class, you'll get comments from me saying that this is an area that's heavily tested, or comments where I might say a great example of this would have come up in con law about a year, maybe 2 years ago now. But on the Louisiana con law bar exam, one of the examiners asked about the word ex post facto. That had not been tested on a con law exam in many, many years, and suddenly it pops up. And so during that lecture, I'm going to mention to you this word ex post facto that comes up, by the way, in the case. I'm going to point it out that, hey, as you read the case, I hope you notice the word. I hope you understand this word means something. What does it mean by any chance? But let's talk about how you would apply this word, because this may come up on an exam. It was recently tested. And so you would be making those notes for your outline. So if students have had success in my class, most of them will tell you that the way to achieve that is not to miss class. Why? Because I really do not teach a lot out of a textbook. In other words, I will assign something to you to read that may be out of a textbook. Sometimes it's an article, sometimes it's a video, but the lessons that we have in class, they're not recorded anywhere. They're very organic, and that's why it's not a good idea to miss class. The examples that I use are often something that is current, something that I think might lead us to a test question on either a final or exam. So missing is always going to be to your detriment for this class. That is not true for every class. Some classes you can miss and do just fine because all you need is to read the code. This is not that kind of class. And so I'm forewarning you, if you're enrolled in a subject I teach, presence really does matter. And I'll talk to you separately about what do you do if you can't be present, but just keep in mind that students will ask, what does it take to be successful? And I start by explaining physical presence is a must. And so you want to make sure your schedule, in your schedule, I should say, law school is included. Because, I have noticed some students will plan their day and law school is an afterthought. It won't work that way for this subject. It cannot be an afterthought for either of us. And so for me, I always plan my day so that I'm prepared, and I'm going to expect you to plan your day so you're prepared. Keep in mind, I've taught these classes before, but I'm never going to show up with my notes from last year. Why? Because my interpretations improve sometimes after I read the responses I get on an exam and realize that maybe I could have explained this better, or because maybe there's been a change in the law, or maybe because there's a new development in another state that might inform changes to come in your home state or this state. So I'm never going to just show up with old notes. I'm going to always be prepared, and I'm going to expect the same from you. So what I'm asking now is for you to begin to spend the first few days really, really having an honest conversation with yourself about these two terms: metacognition, how do I learn? And after you figure it out, making the sacrifice to really be committed to learning, which means that you cannot wait till the end of a semester in order to pull the art of learning off. For classes that I teach, learning is a daily encounter. It is preparing daily. It is discussing daily. It is troubleshooting outlines daily. You never put this down and you never pause. Secondly, the Bloom's part is a journey. You will not progress up the stairs overnight. It's a commitment that you must make in order to improve. And so I'm pointing out to you before school starts, take the time to assess where you are and make some very intentional decisions about how you're going to get yourself up to the very top. There are some things that I did as a law student to get myself to the top, and so I want to offer those before we move on to exam writing. Some of the things that I did was read judicial opinions. Of course, I had to read them to prepare for class, but I picked subject matters that fascinated me, and I looked for opinions on those subjects so that I could read things that I would really enjoy reading. And in my case, what always has intrigued me is the intersection of race and law, social justice, civil rights. Those were topics that I love. And so I would want to learn about any case relevant to any of those topics. And what I started to do was read the way the court, the majority, analyzed. And then I read the way the dissent analyzed. And I often found the dissent to do better jobs. And so there were certain dissenters that I started to really become acquainted with. Of course, your Thurgood Marshall. Anytime I read a Thurgood Marshall dissent, I'm always going to understand the opinion better. And so as a law student, I learned that before I would even read the majority, if Marshall dissented, I'm going to read Marshall's dissent first. Now, what that did was gave me the ability to form an analysis of the same set of facts from two different perspectives. After I understood Thurgood Marshall's analysis, I would go back and read the majority. And then I started adopting the ability to analyze that, the difference, and critique the difference and argue. Notice the word argue and look at this yellow box, the orange box on the screen, because what is it requiring? The ability to argue position. So I could see how the majority was arguing with the dissent, and I could appreciate those differences. Reading those opinions not only taught me how to develop an analysis, but it broadened my legal vocabulary. Also, some of the things that I did was attend lectures. And I want to make sure that you understand that it's not something that requires travel anymore. There's so many professors that are on YouTube with lectures. Many of the things that I do, I now record and place on my YouTube page and use it for teaching material. Other professors do the same, so you don't have to travel the world or have funds to go around and learn from professors. There's also many, many free webinars. I happen to got emails today about 4 or 5 for Martin Luther King Day that are all free. Just log in and sit and learn by listening to experts explain the way they are formulating opinions. And notice the word formulate in that red box because those are the things you want to learn. Another space that I used a lot to improve my critical thinking skills was C-SPAN, book TV. I love books and certain authors that interest me. I love to listen to how they explain things in the books they wrote. That also helped me improve my vocabulary and my analytical thinking. Of course, looking at bar model answers, that helps to improve critical thinking skills. And then practice writing, a lot of practice writing. Practice writing by taking an old bar exam and trying to answer it without timing yourself. And then after you've done that, looking at that model answer to see that I even get the substance of this right. And then after you've gotten accomplished with that, then start now timing yourself so that you can improve your speed. And then after several versions of that, it's time now to start asking a TA if there's a TA, or a classmate if there's a classmate, or a professor, hey, listen, I practiced several times. I think I'm ready for some input now. And then you start having those sessions. Now, I want to make it extremely clear that I am not the professor that you can skip weeks and weeks of material and then show up in my office and ask to talk to me about 3 months of work, because I don't operate like that. It's to your detriment, and I'm not going to encourage that. So I have what is called cutoff periods, and they're listed on the syllabus. And the cutoff is essentially when we finish a chapter, you're going to get a note from me saying that if you have questions about chapter 3, for example, the cutoff to ask me is, and it's usually going to be about 2 weeks from the day we finish. The reason I do that is because I do not want anyone waiting until the end of the semester to come with 30 questions or 45 chapters, because at that point, it's too late for you to master the problems. It's too late for me to help you. And the other problem is that these courses are all comprehensive. And so if you save all those questions to the end, which means that you missed all the real content along the way. So watch those cutoffs. I'm going to be announcing them in class. I'm also going to be typing them in over Canvas. So you need to stay up on material and not wait to the end. Now, what I want to do next is switch to a discussion of actually writing. The writing component of this course is going to require you to be able to use a very specific format. Before we start talking about that particular format, I want to stress to you that all exam questions are not going to be treated the same. You as the student must understand that. So you need to understand, what does this subject require from me as a writer? The subjects that I teach, criminal procedure, constitutional law, they're going to require mostly essay responses from you. So you do need to be able to construct an essay response, which is what we're about to cover. But those subjects are also going to require you to be able to do multiple choice assessments. These multiple choice questions on my exams or on any bar exams are not going to be the kind of multiple choice questions that you had in the third grade, where there are three questions, one question and four optional answers. And then of the four optional answers, three are obviously wrong and one is going to be right. That's not the way multiple choice works in law school or on a bar exam. And so in this instance, you're going to get multiple choice questions where you may have three of them that are correct, and it's a matter of which one is the most precisely reasoned. And so we do have students who fail the bar exam simply because they do not understand how to take a multiple choice test. So one of the ways that I'm going to prepare you for that is by assigning connected quizzing. I assign those connected quizzing questions because what I plan to test through multiple choice is going to be practiced through connected quizzing. So if you do the connected quizzing and you see that I'm not doing well, it is a warning to you that you won't do well on your final, but it's also a warning to you that you may have some challenges taking a bar exam that is mostly multiple choice. Now, there's another thing to consider at this moment in time, which is this next gen bar. That is a new move to make sure that when you sit for a bar exam, the past was lots of doctrinal theoretical knowledge. Now the shift in the country is that you get more practical knowledge in law school. And so some states are in the pilot with the next gen exam. Some states have actually adopted it. So you want to start watching for conversations about next gen, because what next gen does is say, coming to sit for a bar, understanding theory is no longer enough to pass. We want you to understand practical things. And so the idea is that you shouldn't leave law school and have this understanding of what the textbook says the law is, but not know how to use it. And so for many years, law schools would teach you what theoretically you should do. But then when you get to a place with a client where you understand theoretically, for example, the police should not have stopped that vehicle, or the police should not have searched that vehicle, or the police should not have searched that home. You understand theoretically that those things are not proper, but the problem is, as a practitioner, where do you go to tell somebody that that stuff shouldn't have happened? So in other words, like after this arrest happens, you can't go to the police officer and say, sir, I'm the lawyer, I'm calling to tell you that what you did yesterday is wrong. See, that's not the way law is practiced. Law is practiced by you filing something in court, some type of motion. And so what next gen is wanting to know is, okay, yeah, good. You recognize that that arrest was wrong, or you recognize that that search was wrong, but that's not enough. What do you do about it as a lawyer? And so you hear me say things like in criminal procedure, what are you going to file? You'll hear a lot of times I'm going to say things like you need to know that you're going to file a motion to quash, not squash, by the way, quash. Or you'll hear me say things like you're going to need to file a motion to suppress. Why am I doing that? Because I want you to begin to understand that if you had to represent a client, what things do you go before the court to actually file? And those things you need to be able to articulate for an exam like next gem. And also, by the way, for my final exam. Now, you will not be ambushed because during the lectures, I'm going to say it a lot. Hey, if you see this happen, what do you file? What do you file? You'll probably hear it 100 times. And then I'm going to get to the point in the lectures where I say, if you can't answer this, I'm going to combust and I'm going to call on somebody and I'm threatening to combust because I've said 100 times now, you need to know how to say I'd file a motion to quash. So you won't be ambushed. You'll know and you have a very good understanding of these practical areas that we talk about. But I'm only saying to you now that when you hear next gen, the mystique about it is simply it's a shift to more practical things that you would do. Now, what happens if you have a professor who's a great lecturer, but all they do is introduce the theory? That means that you're not getting the practical piece and you need to get it. So how do I get it? Well, if you have a job, that's one way of getting it, but that's not the only way. Courthouses are open to the public. So on your breaks, you should be sitting and observing trials. You should be offering to shadow lawyers. You should be following lawyers into court, asking, do they need volunteers to come and assist with trials? You should be asking professors, hey, listen, I'm not sure I understand the practical piece of this. Can you pair me up with somebody who's doing this work so I can get on the ground and actually see how this happens? Those are responsibilities that you have. So you don't sit back and just allow yourself to be a passenger in a vehicle that is moving along through 3 years of law school. You actually have to become a very active driver. And if you're not getting what you need to either become creative enough to go in self-help or to start being vocal enough with professors to say, listen, I understand what the book is saying, but I'm not sure I know how to do it. So you'll see a lot of me introducing you to those opportunities to learn either through videos or through actual things that are happening in the public. For example, one semester, I had my students assisting some trial attorneys with the trial they were doing because the trial was incredibly relevant to the lessons we were learning in criminal procedure and con law. And so I knew them sitting there watching officers talk about the Fifth Amendment or take the Fifth Amendment was going to be much more impactful than any lesson I could teach in class, or for them having officers explain the grounds by which they use to get probable cause, or how did they obtain a warrant, what was necessary. Those lessons will never be forgotten when you're deep in the trenches of litigation. So that is something I'm a very big proponent of. And so I'm just telling you that you get up blooms by being imaginative. You get up blooms by doing things in your free time that is extremely intentional. If you spend your free time at the tailgate and you spend your free time going shopping for sorority and fraternity clothes and hanging out in the lobby trying to let everybody see how good you look, at the end, when you don't pass the bar, you go back and ask yourself, what did I do with my free time in order to get myself to that top of blooms? Versus that other person that is clerking or volunteering or shadowing or observing or listening and learning and writing and studying, and that person passes because it's choices we make about the things that we value. And so my message to you is I don't want anybody to say I didn't know. And so I'm starting day one by telling you not only what I expect for you to be successful in my class, but what you want to expect for yourself to succeed at being successful as a lawyer. Now, a couple other things, you'll be seeing all of this on the syllabus, what I'm going to say next. And so I'm not going to read the whole syllabus, but I do want to point out that there is a required textbook that you must have for the courses I teach. So make sure you consult your syllabus for that. I do use Canvas, so make sure that you have internet access and that you monitor Canvas, because that is the way I communicate, and I do communicate often. Why? Because I do not ever want anybody showing up in any class I teach unprepared. And so the way I make sure that you will be prepared is by telling you when we start class what I expect, by leaving class and putting it on Canvas. So if anybody wasn't in class, there is no reason for anybody to come back and not be ready to work. So always monitor Canvas to see assignments, for any emails that I think might be relevant, because sometimes we'll talk about something in class. I may be reading an article or watching the news and see a great illustration of that very concept, and I'll send an email and say, hey, check this out. This sort of reinforces this discussion we had. So make sure that you have access to Canvas as well as the connected quizzing. I am again repeating, the way you are going to be prepared for multiple choice questions in this class is through connected quizzing. The way you're going to be prepared for essay questions in this class is through my advice that I'm going to be offering to you next in the form of a how-to sheet. There is a final exam that is done under closed book circumstances, and that final exam will count for 100% of your grade. So there is no extra credit, there is no extra assignments. It is 100% based on your final exam. I do have office hours. They are exclusively done by Zoom. And so those office hours are posted to the Canvas site under assignments. So you make sure that if you do need to see me, that you email me to request a time during office hours. My syllabus is going to tell you that you do not ever use me as your initial resource, that you are to consult your textbook, you are to consult resources in the library in order to see if you can answer your own question. And then if you can't, of course, I'm available. Why do I do that? Because at some point you will be practicing law and you will need to be employable. And so it is my way of trying to prepare you for the workforce, because as a lawyer in practice, there is no one that will employ you if you are high maintenance and you're coming to them all day asking frivolous questions. So you want to discipline yourself to always go in search of resources to see if you can answer your question. And then if you can't, do not ever hesitate to say to me, I've tried, I'm stuck, I need help, because that's why I'm here. I am here to assist you, and I want to be of a support to you on your journey to educational success. The other thing that I want you to understand is that we will have lots of discussions in class. I expect you to participate in discussions. I'll be calling on people, so I expect you to always be prepared. I do not expect you to be indoctrinated, which means that you don't have to agree with everything I say. You have a right to disagree with me. You have a right to disagree with your colleagues. All I ask is that you do so respectfully and with diplomacy, and I will return the same. I also want you to understand that this is a class that fully encourages you studying with other folks. However, that does not mean that you should be sitting absorbing what somebody else does. What that does mean is that you should be preparing individually before you have sessions with anyone else, so that there is equal contribution. Now, I expect that you would look at your syllabus where there's some very, very specific instructions about how to prepare for my classes, because preparing for Professor Bell is way more complicated than just reading a case or reading what's on the syllabus. And so I have very specific steps that I explain on the syllabus, that in order for you to present yourself to be prepared, you need to be physically present in the moment. So you're not just sitting in the seat because, hey, I'm in class, I got my name on the roll. That's not being prepared for class. Prepared is in the mental headspace to listen actively, to contribute actively, to engage in the conversation, to add something meaningful to the conversation. It is asking yourself, did I take responsibilities for the choices that I needed to make in order to come to class ready to contribute? And then preparing in this class also requires lots of preliminary steps, all of which is explained on the syllabus. But I want to emphasize that you will hear me say a lot that context matters. So whenever you're reading a case or watching a video or listening to a lecture, you are not to begin at the first line or the first word. You are to begin in context. And so if the case was written in 1783, I'm going to ask you in class, what is happening in the country at that time? What is happening in the state at that time? Because that ruling is attached to the larger patterns that are taking place either in the state or in the nation. And if you don't understand how to situate a case or a video or a lecture in context, you oftentimes will miss the point. And so being a great historian is a very important part of lawyering. And so I'm going to expect you to be able to acquaint things that we're doing today with the history that might have surrounded these discussions that we're going to be having in these cases. So make sure that you understand context and that you're always ready to talk to me about context. Final thing before we get to essay writing is punctuality. Punctuality means that at least 3 to 4 minutes before the assigned starting time, you are in your seat, that you have your laptop up and ready to go, because I'm going to be giving out an attendance code, and I'm going to expect you about 3 to 4 minutes before class to begin the process of getting your attendance logged in so that we could start class on time. So punctuality doesn't mean a 1 o'clock class starts at 1. It means a 1 o'clock class starts at 1:56. And your laptop is ready to go. You're ready to log your attendance in, and then we're ready to proceed at 1 o'clock. I also want you to understand that I always ask students if we have a unanimous agreement that it is the hour, the appointed hour to begin class. And when that unanimous agreement happens, I close the door and I'm ready to get started. And I do not allow people to come in at their convenience. The schedule is set because the ABA expects you to get so many hours of educational instruction, and you not being there on time means you don't get it. It's also an expectation of professionalism, that as you are practicing or working in the field of law, there is an expectation by your employer or by any court that you will operate in, or any client that you will be working for, that time is going to be respected. And so I am going to ask that of you. Now, the exceptions are if there is some citywide issue, I am normally going to have a door open. I'm normally going to send an email and say, I understand there's been a major accident, and I understand you don't have control this morning. Feel free to, come in, arrive late. But you'll always know when you're welcome to come in, because that door is going to be open. Once I close it, it's time for class to start, and I expect you to respect that. Now, what happens if you have some issue that's going to require you to arrive late? Because that does happen sometimes. We need to handle that in advance. So for example, I've had students who are in clinic and they know that they have an appointment at a certain time. They may have to come into class 10 or 15 minutes late because of a clinic obligation. That needs to be done not the morning of class, not an hour before class, not 2 minutes before class, because I don't even check my phone that often. I don't check email that often. So make sure at least 24 hours at the minimum that you've talked to me in advance, and do not expect that because you sent an email, it's been honored. And so I will acknowledge that I've read your email, that I've granted your accommodation request, that you could arrive later than normal. And only when you have language like that from me should you presume it is okay. Absent that, I'm going to ask that you respect my rule, which is that you do not arrive and disrupt the class. In the past, this causes a lot of problems for students who are trying to focus, and that someone coming in is disruptive, not just to them, but to me as well. So I'm going to ask you to be respectful about being on time, or if you cannot be on time, not entering late. The next part of this discussion is the how to write an essay response. And so I'm going to now share that screen and talk to you about my very specific and required method. I'm going to emphasize the word required because this is not optional. And when I say required, what I'm meaning to you is that if you do not use this format on an exam, I do not read your response. I'm also introducing you to a method that I believe will be very helpful to you if you have to write an essay for any type of bar exam, whether it be Louisiana or elsewhere. I'm also introducing you to a method that you are welcome to use in other classes if you have a professor that doesn't have a certain requirement. And so there's some professors that will tell you that I want IRAC, and if they say that, then you give that professor what they want. But then they'll have other professors that will say, I don't have a preference, I just want a well-written answer. And in that case, you can default to this universally. So what you are looking at is what I call the exam writing how-to sheet. This document is posted on the Canvas page, and it's going to be under files on Canvas. And so you will often see me respond if I'm giving you feedback with EH2S, which means exam how-to sheet, or either H2S, which means how-to sheet. And so you will see comments from me saying, what does section C of your how-to sheet say? What does section R say? You're not complying with section A. And if you see a comment like that, what that is telling you is that I want you to go back to this document. I want you to read what section C should have, and I want you to look at what you did in your section C, and I want you to fix your section C so that it matches what I say you should have. So I'm going to expect that you read this document. And what I'm now doing is simply highlighting some things that I want to be sure you hear and see. So on page 4, you see a visual of how a really good exam essay response should look. And when I say you see the visual, you should see the C means that you state a legal conclusion. And you should also see the R, which means that you give the rule. And you should also see section A here, which means you provide an analysis. Now, I'm only at this point showing you a cosmetic image, a visual image of how a good CRA looks. I am not showing you how to write a CRA just yet. So all I'm doing on page 4 is showing you how it should look. And the way I explain what you're seeing on page 4 and 5 of the how-to sheet is that you should be seeing this as a form of lasagna. And what I mean by that is, as a writer, you do not ever want to produce gumbo. Gumbo is this big pot of love in Louisiana, where you throw in your soul, your arm, your foot, your heart, everything that you feel in your body goes in a pot of gumbo. I mean, it is an emotional act to prepare gumbo in South Louisiana. When you prepare gumbo, you buy the best crabs, the best sausage, you buy an assortment of flavors of sausage. You have to have that holy trinity, which is that celery and the onions and the garlic, and the bell pepper goes in there as well, in subtle amounts. You got to have that filet and the shrimp and the crawfish, and some people even use okra and oysters. Now, the art to this, though, is that you don't have a certain amount of sausage. You don't sit down and say 3 in a bowl, 4 shrimp in a bowl, 2 pieces of crab, you just throw all that love in. When you eat that pot of gumbo and you get the spoon and you scoop some out, you're going to find it impossible to ever get a spoon with simply one thing on it. So you might try to say, I'm only going to get a sausage, but that's impossible because the sausage is going to have a little crab meat on it. The sausage is going to have a little onion or garlic on it. It's impossible to just get a shrimp because the shrimp's going to have some rice on it, right? So as a writer, you want to keep that visual in your head because you do not ever, as a writer, want to give an examiner something on paper that looks like that pot of gumbo, which is telling that examiner, you go in, examiner, just scoop it up. You don't know what may come out. Just go in for the hunt. As an examiner, what is desirable should look like lasagna. And what is lasagna? It is organized. It is layered. Visually, I can see where the pasta starts. I can see where the cheese starts. I can see where the meat is. And more importantly, if I want to just decide that I don't want to have any meat, I'll just separate the meat and put it on the side and I'll just go for the pasta and the cheese. I can achieve that with lasagna where I cannot with gumbo. Now, let me tell you why that's important. It's important because the rules section of your writing has a relationship with the analysis section of your writing. So if you look at pages 4 and 5 of your how-to sheet, you're going to see rule, you're going to see analysis. And this is the most important part of this discussion. The rules section is really an outline for your A section. So if you tell me in rule that I have 4 elements, what you're really telling me is that when I get to my analysis, I'm going to have 4 paragraphs, or at least I'm going to discuss 4 elements. So let's test the theory. Here in the rules section, we have 4 elements. And now let's see what's going to happen down here in analysis. Analysis, we're going to start with element 1, which is state action. And then we're going to go to, wow, look at this now, fundamental right. Look at above, what is element 2? Fundamental right. Let's go down to A. Let's talk about whether the right was infringed. Oh, wow, look at the elements. Is the rights infringed? Happens to be element 3. And then element 4, is there sufficient justification for this? And guess what? This analysis does. Is there justification? So you can see how organized this response is because what I have done is done nothing more than just taken each of the elements from aura and use them in a paragraph or sometimes more than one paragraph in section A. I gave you the visual because many times students don't understand how the lasagna works. And the reason I want you to see it is because I want you to be able to say to me on an exam, when I write the conclusion, there's a blank line between it and the rule. And I want you to say that when I write the analysis, there's a blank line between the rule and analysis. I want you to notice that the analysis is truly just a formula. And the formula has 3 parts. Part 1 is a topic sentence. And a topic sentence is nothing more than me telling the examiner which element I'm talking about. Part 2 is a mini conclusion, and that is nothing more than me telling the examiner whether that element that I'm discussing exists or doesn't exist. Part 3 is me now doing the analysis for that element. And so all I have highlighted here is me explaining how do I think there is state action. I want you to watch this analysis because what you will see here is me linking the definition of state action to the facts and not me drawing legal conclusions. One of the most common problems from law students is what I have highlighted is absent, and students will just give me a conclusion. Like they will say there is state action, or Judge Ban is a state actor. See, that is a legal conclusion. What I am asking you to do is to not give a legal conclusion until you have first done the analysis of it. The analysis is, how do I arrive at this thought that there is a state actor? The analysis is the why do I think that? What facts tell me that? And so I'm going to go through every fact that I had to think about. So in here, this judge is not out on a Saturday dressed in his pajamas making decisions, but this is in the middle of the official workday. He's in work uniform. It's on work hours. He's been presented with a couple who needs to have work done by a judge, and he makes a decision in that capacity, and he's being paid by the jurisdiction. All of those things make him a state actor. And so all of the thoughts that I had to consider to come to that conclusion, they become a part of my analysis. So what you see here is the formula. Now, when you take an exam, the most important part of the exam to the examiner is analysis. So I am introducing you to what is a formula that you have to master by the time you get ready to sit for my final exam or for your bar. The formula, once again, topic sentence first. The formula, once again, end with a mini conclusion. The formula, once again, is everything in the middle, is analysis, not conclusion. All right. Now, I want to also talk about a secret. And the secret is that as an examiner, I do not have an obligation to read each element of your analysis. And an obligation that I don't have, I'm not going to honor. And so what I am doing, and you will not know because I'm not going to disclose this, is on an exam, I may not have any interest in grading state actor. Why? Because I may say that is so easy. There's no challenge to that. You're not going to have problems in practice on a bar arguing what a state actor is, so I'm not even going to read. You don't know that, though, because I don't have a duty to disclose it, and I won't. So you don't know what I don't want to read. But really, in truth, what I probably only want to read here is B and C. Do you have a fundamental right? And is that right infringed? Now, if you do lasagna, look how easy it is for me as the examiner to read B. How is it easy? Because I use the topic sentence and a mini conclusion that uses the element fundamental right. And look how easy it is for me to do element C. Why? Because I use the topic sentence and a mini conclusion that talks about element 3. Now, if you did a pot of gumbo, I would not have the luxury of going in and finding element B and element C, which is why I am urging you to understand the need to use this lasagna format. Now, what exactly is the format? I've already said to you, my format is C, aura, and A. So on an exam, I'm going to want you to give a conclusion. I'm going to want you to give the rule, and I'm going to want you to give a really sound analysis. This sheet tells you how to construct each part. I will not be going over every word on the sheet, but I am directing you so that you understand that I expect you to read this. I expect you the first day of class to understand that you should have mastered this. And I expect you the first day of class to make a very tactical decision. If I don't know how to do this, I'm going to have to start troubleshooting, because waiting until the end of the semester to learn it is too late. After you read how to construct a C, my advice to you is to go to the end of the document where I have examples and say, okay, I read what that tells me. Let me look at the examples. Here's one example of how to construct a C. For me, the C has to answer the question I asked, and the C has to speak in indefinite language. So simply read the C. They have a high likelihood of success. So that's answering the question on the issue, which is due process. So with my C, I don't want you to give the issue is, I want you simply to weave the issue into the conclusion. And so I'll know what the issue is by reading the way you write the conclusion. Now, on page 4, you have an example of a conclusion. Guess what? On page 6, you have another example of a conclusion. Guess what? On page 7 and page 8, page 8, you have more examples of a conclusion. Okay, so here is another conclusion. Then if you go to page 9, you're going to wind up seeing what? Another example of a conclusion. You go to page 10, you're going to keep seeing this. So no student should ever get to a final exam and see a note from me that says, you didn't follow the how-to sheet when you wrote your conclusion, but guess what keeps happening? This is my feedback on a final exam that I recently gave, and guess what it says? There's a problem with your C-section. Why are you talking about something I didn't even ask? What does the how-to sheet tell you about the call to the question? So this now is something I just taught this to students last year, and this is papers I graded last year, and I'm still getting people who simply cannot write the conclusion, which is the easiest part. So I'm explaining to you with 9 examples here, this should not happen on your final exam. Then the how-to sheet, if you go back to page 1, says, okay, now that I've explained how the conclusion should be written, giving you repeated examples, let's talk about the rule. How do you write the rule? For me, you have to begin your rule section with the word under. That is a must. And then you have to use element format, but you can do elements vertically if you wish, as you see illustrated. You can do them horizontally if you wish, or you can do them with underlining, or you can do them with numbers. Okay, so you have 3 options. Now, I'm going to again direct you to the end of the document where I give you repeated examples. So page 4, this shows you rule starts with the word under, and there's elements written vertically, okay? Then if you keep looking, I'm gonna go down to example 2, and guess what you see? Rules starting with the word under, and then you see the elements vertically. Continue on throughout the end of the document, and you're gonna see again now example 3, and what's in example 3? A rule starting with the word under and elements vertically. Again, I have repeated examples here of how to write a rule. However, on the exams that I gave recently, you will see under the feedback, many of the students are getting feedback from me that is telling them that there's a problem with the rule. The typical problem I get is you don't know the rule. Now, that is a real big problem because look at this note, feedback that I'm giving to the student. You did not demonstrate mastery of elements 2 and 3. Now, the reason that that becomes a problem is because of what I said to you about the relationship between the rule section and the analysis section. So if the rule has 5 elements and I'm telling you that means your analysis should have 5 elements and you don't know the elements, rule wrong means analysis is always wrong. Now, analysis is where most of your points are going to come from. For me, analysis has to begin with the word here. You want to remember the formula that I just explained. Topic sentence first, mini conclusion last, and then analysis of that element in the middle. If you look at the how-to sheet, I'm going to give you a second to look at page 3 of the how-to sheet. If you look at page 3, it may seem very bizarre in law school to have this toddler preschool sheet as my way of teaching you legal analysis. But what I'm trying to train you to understand is what you see illustrated on page 3 is the mental work that you must do on an exam. Some students can't do mental work without doing physical work. So literally there are some students on an exam that will do this in the margins. So they will say if element 1 is state actor, they envision that cat. And they say now if the element cat is state actor, the cat plays with yarn. So where's my yarn? In other words, what facts link with state actor? And so literally, we are linking with the word state actor things that tell me that the person is acting for the state. So who pays that person their pay? What uniform do they have on? What's the hours of the day that they're doing what they do in? Is it state work hours? Then that becomes the yarn that I'm linking here with this cat. So when I write the analysis, what I'm telling my examiner is not things like John is a state actor, but I am linking the facts to say that in this scenario, I'm looking at the uniform John is wearing and it says state of Louisiana. I'm looking at the hours John is working and it's the hours that the state bank is open. I'm looking at the training manual from John's job that says state training guide. I'm looking at the paychecks. So all of these are linking methods to tell that examiner that when I link all of these pieces of yarn together, I get a cat on the other side. Or when I blend the word state actor with all of these details, I get proof now that the person is acting not in a private capacity, but in an official governmental capacity, which is the goal. So that is what this is illustrating on page 3, basically the mental work. But I also get students saying, I don't even know what an analysis is. I mean, I've heard the word, but nobody's really helped me see it. And so I'm trying on page 3 to not just show you the mental work, I'm trying to define it. But then when I go to these examples, I'm showing you how analysis looks. So analysis is all of this stuff that is between the topic sentence and the mini conclusion. Now, what I also tried to do to help you was to show you on pages 8 and after some papers that I've received from students who do not understand analysis. So as much as this document is here to show you what analysis is, this is also an attempt to show you what it is not. And so example 3 is a student who only got 4 points out of 15 possible points. So I want you to see the question that I asked the student, and I want you to see what the student said to me. And all I did was literally cut and paste the response from ExamSoft. But at the end of each of these, I want you to see the feedback that I gave to explain why the student scored what they scored. So this feedback is telling the student your conclusion is a problem because you're not answering the question. So you're losing points on the conclusion. Then it's telling the student your rule is problematic because when you get to analysis, you don't know how to apply it. And so you have elements 2 and element 3 that you can't apply. And remember now, if all of your points come from the ability to apply the facts to the law in your analysis, and you're missing 2, and it might, by the way, be the 2 that I'm going to grade, you're already in trouble. So you can see how this student ended up with only 4 points out of 15. That's example 3. Example 4, this student got 15 points out of 15. So this is my attempt to show you how somebody has demonstrated a sound analysis. Notice I didn't say perfect analysis, I said sound, which means that this is the best one out of the class. I don't mean to suggest it's flawless or perfect, because sometimes there'll be typos, misspellings, sometimes a couple of sentences that I would have done better. But this means out of the entire class, this is the best sample that I got. And look at the feedback that this student gets from me, model paper. So I have nothing that I would change on the way they wrote their conclusion, the way they did their rule, or the way they did their analysis. And if you look at example 5, this student gets 8 out of 15. So this shows you kind of the person in the middle. And then you can take a look at those comments that middle paper is getting. Look at this again. Simple part here of the question is your conclusion. And you have a student here that's giving me half the conclusion right, half wrong. But then the student does not know how to do an analysis of elements 2 and 3. So that student is not going to be able to get maximum credit because of that. And you see example 6, feedback again. Look at the feedback to example 6. Hey, you gave me a pot of gumbo. Now, what happens when you give me gumbo? I don't eat it. I only eat lasagna on an exam. So you're going to get 0 points for A because you gave me a pot of gumbo. And you should know what gumbo is now, because how do you know? This tells you that when you write your A section, that your A section is essentially going to take each of those elements that you gave me in aura, and it's going to do the formula per each element. And if you don't do that, you have gumbo. And all of these examples are in place for you to be able to say, I'm going to convince myself that I know how to do this by reading through these examples and saying I would have done this perfect, right? Or I'm reading this realizing that I don't know how to develop an analysis like this, and I need to take the next few months to perfect that skill. So what I'm asking of you to do is to, one, understand my method is CRA, understand how to construct a C, which is explained on page 1, how to construct a rule, which is explained on pages 1 and 2, and how to construct an A analysis, which is explained on page 3. And then I expect you to say, now that I get the concept, let's go to the application. Can I actually do it? And I want you to understand that this document is going to be invaluable. So you need to study this as if your life depends on it, because it does. The example should answer questions, but if it does not, I am letting you know the very first lecture is going to be devoted to questions relative to how do I write. So if you have any questions about writing, please present them during the very first lecture. I thank you for your attention, and I am looking very forward to providing instruction to you this semester, and to us learning from each other, and to us essentially preparing you not only for success in this particular class, not only for success on the bar exam that's ahead, but for you to be a successful colleague of mine in the future. Thank you for your attention.